About a week ago, we talked about how the National Labor Review Board actually issued an opinion, not a judgment, an opinion that drivers were independent contractors and not employees. But in their opinion, did they actually give drivers the legal maneuver they need to finally take down Uber? Hey everyone, this is Kevin the Apptrepreneur, and yeah, this is going to be a very interesting video. I was reading an article on Jalopnik, and they pointed out that the National Board Review, which, as just previously stated, did put out an opinion that drivers were independent contractors based on several things. Primarily, we can get on and off whenever we want. But this person who writes for Jalopnik, believes that in that ruling, in that opinion, because it's not a ruling, it's an opinion piece, that they might have actually given drivers some legal ammunition to basically reclassify themselves or take down Uber, whatever. We're going to read the whole article. It's a very complicated article. And just to give you a heads up, this will not be a short one. This will be long for certain because of the sensitive nature of the topic. But before we talk about any of that, let's have a word from our sponsors. Times are changing for gig workers and the gig economy, and there are a lot more gigs from a lot more companies than there used to be. That's why when people ask me where they can go to find resources for the gig economy, I recommend gigworkers.com. At this site, you can see what other gig workers are doing and discover better opportunities. From industries, companies, resources, and even a forum where you can talk with other people in the gig economy, gigworkers.com is a great resource site whether you work for Uber, Lyft, Postmates, DoorDash, TaxRabbit, Thumbtack, Upwork, whatever. There's a gig for you and there's a forum for you on gigworker.com. Gigworker.com for all your gigs. And here we go. The legal argument that could destroy Uber. It starts, days after Uber began selling stock, the National Labor Relations Board's top lawyer gave the company a huge gift. In an advice memo, keep in mind, an advice memo, not a ruling, the General Counsel's office determined that Uber's drivers are independent contractors, not employees. If drivers are legally determined to be employees, it would throw Uber's entire business model into question by giving drivers, among other rights, the ability to collectively bargain for pay and working conditions. Which I think you kind of already have that bargaining power, you just don't exercise it on a grand scale. You don't like what they're doing, it is true. Stop driving for them. That's how you get their attention. Not a lot of people want to do that, but, whatever. That's why I still have a job here, right? While the memo itself is not a court ruling with legal authority, it's yet another influential voice weighing in on a vitally important legal distinction for Uber and other gig economy companies like it. So again, not a legal court ruling. But a ruling in the company's favor would paradoxically expose the ride-hailing giant to a separate legal challenge, one that has gotten far less attention. It poses an even greater existential threat not only to Uber, but most, if not all, the gig economy businesses. Price fixing. Quote, Uber is effectively trying to have it both ways, says Sanjukta Paul, a law professor at Wayne State University who has been writing about the gig economy's vulnerability to price fixing regulation for several years. Quote, they're setting a price for a product they say they don't sell. Interesting. Let's continue. And by the way, because of the legal nature of it, that's why we're reading the whole thing. That's why this is a long video. This legal argument is deceptively simple, but to understand it requires laying a lot of groundwork, not just to understand the argument itself, but why the American legal system has largely stopped paying attention to these kinds of antitrust concerns. It's also important to break down why price fixing is central to the employee-contractor distinction on which so many companies depend in the first place. Now, I have a pretty good idea of where this is going, and you might be getting an idea too, but let's continue. A warning up front, this stuff gets confusing, sometimes intentionally so on the parts of companies that want to muddle the distinctions between workers and contractors, customers versus vendors, and other distinctions very important in the legal realm, but rarely of interest to ordinary people. Whew, that's a mouthful. But understanding all this is key to grasping the nature of work in the internet age and how the law lags woefully behind. So, and then there's a little quote here. This is precisely I think that's for later in the article. Nearly all the important distinctions in American labor law were determined before the internet. As such, one of the most important differences in American labor law is between who is and isn't an employee. All workers are equal under the eyes of the American court system, you see. It's just that some are more equal than others. Among other perks, American labor law grants a number of protections to workers who are officially employees, but hardly limited to the right to organize and collectively bargain. However, independent contractors who can have limited liability corporations or other incorporated entities in their own right do not have many of those rights, including the right to collectively bargain. But if ride-hailing drivers are independent contractors and not employees, and thus they are all different corporations for the purpose of this legal argument, that brings up a big problem. This is because we have a different label for when different corporations get together and determine the cost for their services. We call it price fixing. And price fixing under the Sherman Antitrust Act is illegal. In other words, by labeling drivers independent contractors, it prevents them from getting together and determining how much they should charge for their services. In the same way that every locksmith can't get together and agree to a minimum price for getting you into your apartment when you lost your keys. This is precisely the argument business groups have used to block independent contractors from unionizing, and it is a bit of evil genius on the part of companies like Uber. By declaring its drivers not employees but independent contractors, it not only doesn't feel any obligation whatsoever to guarantee its workers things like a minimum salary or benefits, but at the same time can completely deny them the right to unionize. See, this is going to get complicated. In Seattle, the employee-contractor issue has been the crux of a legal battle whether for-hire vehicles are allowed to organize. In 2015, the city passed a law that would have allowed one union to represent all of Seattle's 9,000 ride-hail drivers. U.S. Chambers of Commerce sued the city of Seattle to prevent the law from being enacted. Here's Reuters' explanation of the Chamber of Commerce's legal argument. The chamber argued that by allowing drivers to bargain over their pay, which is based on fares received from passengers, the city would permit them to essentially fix prices in violation of federal antitrust law. Even though that's technically what Uber and Lyft themselves do, but you know. The case is still ongoing, but it's worth thinking through the implications of the Chamber of Commerce's and by extension Uber's argument. Uber has furthermore argued in legal filings that drivers are, in fact, their customers, because Uber sells drivers an exchange service to help them in turn find their customers, the riders. This is a weird argument for a lot of reasons, but it accords with the company's contention that it's a platform, not a transportation service. By this logic, Uber's product would not be the actual transportation of the person from A to B, but the use of this app to facilitate it. Therefore, the price of Uber service would not be the $35 or whatever you pay for the ride, but Uber's cut, the $8.75, 25%, the company takes for itself. When Paul walked me through this argument, this was the point I had my aha moment. So this is the aha moment. In practice, the company sets the price for more than its own services. Uber determines the price for the ride itself, which it contends is a transaction between two separate entities. In other words, there's an argument to be made that Uber is doing the very price fixing it says drivers can't do, and the price it fixes is for a service it contends it doesn't sell. That's getting really interesting, huh? Let's continue. Presumably, Uber would argue in a court-like setting that's perfectly fine because it's a single firm, whereas independent contractors are a collection of thousands of firms. But Paul argues this is a distinction without a difference. The price, after all, is still being fixed. When Jalopnik asked Uber if it has any comment on the potential legal challenge of price fixing, an Uber spokesperson did not answer the question and instead sent the following statement. I'm going to love this. Riders want a reliable and affordable way to get from A to B. Drivers want dependable earnings. Our pricing is designed to meet the needs of riders and drivers, so Uber can be the first choice for both. So, yeah, that's their way of saying no comment. Throughout Uber's history, drivers have repeatedly claimed that they find Uber's payouts misleading and unpredictable. Well, of course they do. We have the upfront pricing in which we never know what we're going to get. To be fair, this is tricky and shifting legal territory. What we're talking about here is different than what most people think about when they picture traditional price fixing or other cartel behavior, like a bunch of mob bosses or Fortune 500 executives gathering in a smoky back room. In that popular conception, firms are engaged in what's called horizontal coordination, akin to if Uber and Lyft set ride prices together. That is still very much illegal today. But but vertical coordination, where a single firm or supplier sets prices for everyone it contracts with and resells their product or service, like if Ford controlled the exact price of every F-150 at all of its dealers, has a complicated legal history. For much of the 20th century, the courts did not look kindly on so-called vertical coordination. The rough idea was that if you wanted to coordinate prices, you had to run your business as a single firm, requiring workers to become employees and get the accompanying rights. It was a way of enforcing some degree of fairness in the labor market. You want to tell other people what to do when they work, including what price to charge? Fine, make them your employees so they get rights of their own. But starting in the 1970s and continuing through the 1990s, the Supreme Court gradually loosened rules around vertical coordination rights. The first major decision came in 1977 in Continental Television Inc. versus GTE Sylvania Inc., when the Supreme Court started to use the so-called rule of reason. No longer was vertical coordination in itself illegal, but courts now weighed in as to whether or not it was anti-competitive. Because, yeah, that just makes it a lot simpler. If not, then they had no problem with it. This ruling was cemented and broadened in 1997 under State Oil Co. versus Kahn, which overruled a 1968 case finding vertical price fixing illegal. Thanks to the Supreme Court allowing more and more vertical coordination, large businesses had the law's blessing to control smaller actors, even ones outside their firm. The onus was now on the plaintiff not only to prove there was vertical price fixing, but that it was promoting anti-competitive behaviors. So, say a fast food corporation could roll out a national value menu, even though most McDonald's restaurants around the country are independently owned and operated, without obviously violating federal law. Uber and other app economy businesses took it a step further. For one, the price setting is happening digitally via an algorithm Uber controls. But more importantly, they also changed the very nature of employment, which broke some long-held assumptions of why more vertical coordination is permissible. Even fast food value menus are, according to Paul, a hazy area in the law and one nobody, least of which the corporations themselves, want to test in court, although in Europe there have been antitrust cases about this very issue. But some of the fuzziness there is due to how much control Burger King actually has over the prices franchises charge for a Whopper. There's no such fuzziness with Uber, which quite clearly determines prices that independent contractors must charge. You see where we're going with this? Paul described this less as Uber doing something completely unprecedented and more of pushing legal boundaries further than anyone else, to the point where it begs some questions. Quote, they just have more chutzpah. I can't believe I knew that word, chutzpah, she summarized. They've pushed their luck to a level that actually drew consumer complaints. Because that's usually what will do it. In 2015, Spencer Meyer, an Uber rider from Connecticut, sued Uber co-founder and then CEO Travis Kalanick, alleging the company fixed prices in violation of the Sherman Antitrust Act. And now we finally get to the simple part of the argument. The suit's logic was very straightforward. Uber fixes the price for the service other companies provide. This is price fixing. Hard to argue with that one. But the courts never ruled on the issue because of another separate structural issue with American labor law, arbitration agreements. This is where it gets sad. Uber's terms of service, like those of countless other companies, waive both customers and drivers' rights to jury trials or class action lawsuits, instead directing litigation to arbitration instead. Meyer's lawyer even made the very creative argument that an iPhone keyboard automatically popping up over the hyperlink to the terms of service prevented it from being legally binding, but the judge didn't buy it. Yeah, but that was a nice try. You gotta give him that. Uber has amassed more than 60,000 arbitration cases to handle, although it's currently working on a settlement for a large majority of them for a total bill of around $150 million. In his final ruling upholding the motion for arbitration, Judge Jed S. Rakoff did not hide his scorn for such duplicitous tactics hidden within lengthy terms of service agreements. This being the law, the judge must enforce it, even if it is based on nothing but factual and legal fictions. Meyer's attorney in this case did not respond to calls or emails. I know the confusion is probably mounting with all the contradictory legal arguments, but here's even more confusing stuff. Really, it gets more confusing? Last year, a Massachusetts appeal board ruled that very same arbitration agreement is in fact not enforceable. The courts obviously are still working this out. But as long as these arbitration agreements have at least the veil of enforceability, it will be harder for riders to challenge Uber on price fixing. Drivers have a better shot than riders do. Remember how the courts are now using the rule of reason on vertical coordination cases and plaintiffs have to prove anti-competitive behavior? Uber's juicing of both sides of the supply-demand model with heavy incentives means drivers have a better case for harm since Uber is using investor money to make cab rides artificially cheap, effectively capping a driver's potential earnings. Which is why you probably won't see any captain of the 3K club anytime soon. But the onus isn't completely on drivers to sue Uber. The Federal Trade Commission could, and here is where we get to the biggest failure of all. Whew. Let's take a deep breath. We're almost there, guys. Over the last several decades, the FTC and the federal courts have cultivated a business-friendly environment thanks to a revolving door of regulators bouncing back and forth between government and the private sector. The current FTC chairman, Joseph Simmons, appointed by President Donald Trump and a Republican who formerly worked for a prominent law firm defending businesses in antitrust cases and getting mergers approved, talks a big game about reining in tech companies, particularly around privacy issues. But in September, he named Gail Levin the new deputy director of the Bureau of Competition. Prior to that, Levin's title was Director, U.S. Competition for, wait for it, Uber. Yep. I mean, actually, I've made videos about things like this. Regardless of whether the FTC has the willingness to bring a case against Uber, the courts are simply aligning in favor with big business, particularly the Supreme Court's rightward shift, which would presume less willingness to act on antitrust matters. There are potential solutions to this gigantic mess that appears increasingly untenable. Paul's preferred solution is twofold. First, she advocates for the courts to clamp down on vertical price fixing to some extent. Second, and perhaps more importantly, she thinks the courts should allow for small businesses in limited cases coordinate among each other in ways not currently allowed by antitrust law. So drivers could organize regardless of their distinction as employees or contractors. But these solutions would fundamentally require government agencies tasked with overseeing these companies and the courts that rule on legal challenges to do their jobs protecting American workers from exploitation, along with adapting to a rapidly changing definition of what it means to work and for whom one labors. So far, they haven't done that. Or, as Paul put it, antitrust agencies seem very happy to rescue these companies from the rock and a hard place they find themselves in. So yeah, there you go. That is the detailed description of the legal argument that could destroy Uber. And it's one that I've actually brought up a few times. Because one of the reasons I feel that we are employees is that Uber picks the pricing. We don't control the pricing. I mean, they set a rate for us and we have to accept it or else we don't drive for them. So, and for all the things they shout about, oh, you have freedom to choose to do this and choose that, you really only have one freedom. Whether to turn the app on or to turn it off. And as Mark from Uber Hits pointed out a few days ago, if, the technical difficulties continue, well, Uber and Lyft don't even want you to do that much. So, what are you going to do, right? But anyway, I would like to leave this question off to you. What do you think? Do you think the fact that you can't set your own prices is a huge legal problem? Do you think anyone would ever seriously challenge Uber on this issue, or do you think this is a non-issue? Maybe there's some lawyers in there. Maybe you can explain if this argument by Aaron Gordon has any validation whatsoever. I would love to know. So, Comment below, like, favorite, share, subscribe. If you enjoy my videos, consider becoming a Patreon member. It's totally optional, but even as little as $1 a month goes a long way to helping the channel run smoothly, and you get access to my Patreon's exclusive blog. Also, check out the Apptrepreneur Vlogs channel. It's fairly new, and we're trying to put new content up on a daily basis to the best of our ability. And if you want to talk to me or other people on this channel, check out the Apptrepreneur Hangouts on Facebook. Oh, and finally, if gas prices are getting you a little down, check out the Get Upside app. It's free, but you get cash back on every purchase. And as always, flame responsibly. Have a good one.